Oh my god. How about you like not say that right here? I've been trying to come see you, but Wildfire is an asshole. Who? Somebody called me this morning, today. Yeah, like the 494 number. Yeah, they were like, hang up the phone. So I sat there with the phone and I'm like,
One time. Good.
I talked to Jermaine last night. Huh? Yeah, he's mad as fuck. He's getting over it though. He's like starting to
Yeah, we'll talk.
I know, I tried. I woke him up last night. I was like, come get me. And he was like, I'm sleeping. Would you get a job? There was a reason. My mom could bring me out, but no process till Saturday. Huh? Yeah.
Ja, nej, inte. Well, second day.
Huh?
Second day.
Just the address and what world is it? 402. Yeah, it's 1651 Maryland.
So you live right where Junior lives, right where Junior lives.
I live
Is that
at
the front, is your front yard a pond?
No, I'm behind that. I'm right behind that.
Oh,
It's
okay.
behind.
So Junior
First
front,
unit.
so Junior back, Junior, like, I'm on back is your front there.
Yeah. Oh, in the second driveway on the right. When you come in, you pass the first driveway on the second one.
So you do the same, like, you come to the back, and then go to the right, the kitchen, and back there. You go on the living room,
Well, it depends where you're coming from. If you're coming to back.
It's not done.
You know, Tim's out.
Now you got Jeep. You got Jeep.
Nothing really, I don't know. You know how he just talks? And I just act like I'm listening. He's on your list?
It's probably didn't get anything involved in the 24 prior to being transported. It's only fill that stuff out, so I'll take over the request for appointment from council, get that finalized, and just so hopefully it's appointed soon. Because again, 30 days from to file on time and fashion. Obviously, if they're turning more time because they would use the grant criteria. Sure, good follows on the report, it doesn't get more time.
All rise. This court of common please is now in session. The Honorable Eugene A. Bucci presiding.
May proceed. This is case number 18CR732, State of Ohio versus Manson M. Bryant. Mr. Bryant is in court represented by counsel, attorneys Jerome Emhoff and Dan Williams. Representing the State of Ohio is Assistant Prosecuting Attorney Alexandra Cutts. The defendant went before a jury trial starting February 5th, 2019. On February 8th, 2019, the jury returned its verdict. The verdict was guilty in count 1, aggravated burglary, felony 1, with a firearm specification, both a 3-year and a 1-year. Guilty in count 2, aggravated burglary, felony 1, with the same 2 firearm specifications. Guilty in count 3, aggravated robbery, felony 1, with the same 2 firearm specifications. Guilty in count 4, felony 1, with the same 2 firearm specifications. Guilty in count 5, abduction, felony 3, with the same 2 firearm specifications. And guilty in count 7, which I renumbered for the jury as count 6, of carrying concealed weapons, a misdemeanor of the 1st degree, the jury determining that they did not find beyond a reasonable doubt that the firearm was loaded or for which ammunition was ready at hand. On that date, I found the defendant guilty in count 6, the actual count 6, of having weapons while under disability, a felony of the 3rd degree, and I found the defendant guilty in count 7 of carrying concealed weapons, a felony of the 4th degree, based upon the stipulation of the parties that the defendant previously was convicted of an offense of violence. At that time, I indicated to the parties my preliminary thinking on the issue of merger. The parties filed sentencing memoranda which covered the issue of merger. I've met with counsel and probation in chambers and told them what I would do with regard to merger, and I'll put that on the record at this point. Court determines that count 2, aggravated burglary, felony 1, merges into count 1, aggravated burglary, felony 1, and the court will sentence on count 1. The court determines that count 5, abduction, felony 3, merges into count 4, kidnapping, felony 1. The court further determines that kidnapping, count 4, felony 1, will merge into count 3, aggravated robbery, felony 1. There are a couple of factors that would weigh in favor of treating kidnapping as a separate sentenciable crime because of the covering of the head and the 5 minutes maximum that this could have occurred, and the poking of the defendant's forehead and face with the firearm. However, the court determines that that additional animus is de minimis and part of the aggravated robbery, so I am merging count 4 kidnapping into the aggravated robbery. The jury's verdict, the misdemeanor 1 CCW, would merge into the court's count 7 CCW, which is a felony of the 4th degree, and the court determines that count 6, having weapons under disability, and count 7, carrying concealed weapons, are 2 separate crimes. You don't have to have one to do the other, and that the court will not merge counts 6 and 7 and will sentence on both. So accordingly, the court will sentence on count 1, aggravated burglary, felony 1, count 3, aggravated robbery, felony 1, count 6, having weapons while under disability, felony 3, and count 7, carrying concealed weapons, felony 4. The court did refer to the defendant for an updated criminal record. The court previously sentenced the defendant to prison, and at that time had a full pre-sentence investigation done. The Adult Probation Department did provide an updated criminal record dated February 21st of 2019, and the record, not only the pre-sentence record, but the DRC shows that the defendant was released from prison on my last sentence of him on November 15th of 2017. The court also has received victim impact statements from the victim, Arturo Gonzalez Hernandez, and Ms. Martha Murillo. The defense has filed a motion for new trial, and it was based upon the defense's desire, and this motion was made during the trial, and as a motion in limine, it was covered before trial started. The defense wanted to cross-examine him on the application for a U visa, and the court ruled that the defense could not get into that. I ruled that before the trial. Nothing that happened during the trial changed my mind about that while the trial was pending, and as I sit here in retrospect, the court is of the opinion that my ruling was correct, and in fact, the court did not hear anything that I would consider embellishment, and in fact, I'm not sure he even qualifies for a U visa under the facts as he testified to, but that's for the federal immigration judge to make that determination. But the court's opinion of the evidence was that Mr. Gonzalez testified consistent with what he told the police, and that the court didn't see any exaggeration or embellishment in his testimony on that topic. Actually, had he embellished, there probably would have been a felonious assault charge added to this, and also I would have found the kidnapping was such that that would be a separate animus, and that I would sentence separately on that. So the motion for new trial is denied. And is there any reason not to proceed to sentencing at this time? Mr. Williams?
No, Your Honor. Thank you.
You may address the court first.
Yes, Your Honor. As the court's aware, a sentencing memorandum was submitted by the defense prior to today's hearing. I believe the court's summation of the issue of merger largely mirrored what defense had submitted as far as merger of the charges. I would just briefly address the issue of mergers to counts 6 and 7, that being the weapons under disability and carrying a concealed weapon. While there are certainly circumstances in case law to support, I believe some case law was actually cited in the state's sentencing memorandum, where these two offenses have been found not to be subject to the merger doctrine. In those situations, I think it was more so speaking to an individual who actually acquires a weapon prior to commencing a criminal offense, and then obviously uses that weapon in the course of a criminal offense. I think here our situation is distinguishable in that Manson Bryant was convicted essentially under an aider and abetter theory. There was certainly nothing to indicate that he took part in the actual acquisition of the firearm by Mr. Bynes. There was nothing to indicate that he actually physically possessed that firearm throughout the course of the crime that was committed here. For that reason, we feel it's distinguishable. The so-called, essentially the possession of the firearm was all part of a continuous course of conduct, and Mr. Bryant was found guilty of those offenses based upon being an aider and abetter to Mr. Bynes in the commission of this act. As to the sentence, Your Honor, obviously the court has at its disposal here, given the number of offenses, the firearm specifications, the court can craft a sentence here that would essentially keep Mr. Bryant in prison until he's a ripe old age. But we would only note that, retribution is not the only goal of the legal system. Rehabilitation does carry equal weight, and a sentence that would essentially, prohibit Mr. Bryant from being afforded any meaningful opportunity to redeem himself and live a law-abiding life would not be in line with the purposes and principles of sentencing. We are asking this court to consider a 10-year aggregate sentence. We feel that would not demean the seriousness of the conduct here, and would not demean, essentially the role as a aider and abetter that Mr. Bryant was found guilty of here. We feel that sentence would be commensurate with sentences that have been imposed by this court for similar crimes and against similar offenders. The court is aware that the principal actor here, Mr. Bynes, did in fact receive a 12-year sentence, and we feel a 10-year sentence is in part for the role that Mr. Bryant was found guilty here in this particular offense, and such a sentence would provide him the opportunity to live a meaningful life and prove to himself and to the court that he is capable of rehabilitation. Thank you, Your Honor.
Manson Bryant, the law allows you to say whatever it is you want me to consider before I sentence you. Is there anything you want me to know?
Yes, sir. Your Honor, I know you very well aware of my history. I made a lifetime of bad decisions. And those bad decisions has caused pain to a lot of people in my family. For that, I am truly sorry. Most of my bad decisions have been driven by my addiction to drugs and to do whatever I can to continue to get high. My ability to stay clean has me to spend most of my life in prison. There's no way for a person to live. That's no way for a person to live. And it's not how I want to finish my life. And despite the circumstances of my upbringing, I understand that I can't continue to blame others for my actions and my behaviors. I become jaded towards the court legal system by having this trial was an honest and open fire for me. I have never gone through trial before. I have a newfound respect for the efforts of the attorneys, judges, juries, and go in living as giving the accused person an opportunity to have a case heard. That's all I wanted to ask. I am thankful for the opportunity and afforded by the day in court, and I respect the decisions that the juries have made. I alone have the power, to end the cycle of incarceration, and all I ask is for you to give me an opportunity to still make something out of my life, sir. I don't want to die in prison, sir. I'm not a bad person, sir. You have a drug problem. You know, I've been in front of you multiple times. I respect you. And I respect the decision that you make.
All right.
Thank you.
Do you have any witnesses to present?
No, Your Honor, thank you.
All right, let me hear from the state.
Thank you, Your Honor. Just in reply to the merger argument, the state also filed a sentencing memorandum that does deal with the merger issues. And count 6, having weapons under disability and carrying concealed weapons, count 7. Through the case law, they have separate animus and they do not merge. Goes back to the Ohio Supreme Court, many districts. The acquiring versus the concealing of the weapon are separate animus, regardless of whether Mr. Bryant acquired it or Mr. Bynes acquired it. Mr. Bryant was aware of that. They had it in the condo well before they left to do this. They were aware of it, and the need to conceal it makes it different as well. So we do feel there are separate animus, and there are no reason that those would merge even in this case. Also, there was an argument made that there need to be, well, I'll get to that. For sentencing, Your Honor, obviously this court has heard in detail the facts of the case. I don't want to go over them extensively, but just looking at the factors in this case, they are laid out in the sentencing memorandum. However, just so the record is clear and others can hear, obviously the victims, Mr. Gonzalez and Ms. Murillo, both suffered serious psychological harm. Obviously, Mr. Gonzalez was present as people unknown to him enter his home without permission, terrorize him, steal from him, as the court has made reference to, pointed a gun at him, pushed it against his forehead, pushed him back, threw a blanket over his head, continued to move the gun around his body, feeling it in his rib cage as he was punched in the head. Even when they left, it left a lasting impression to the point that he left that location. He no longer lives there. He didn't feel safe or comfortable there. He was renting that room for Ms. Murillo. She has also had concerns because she came home as Mr. Bryant and Mr. Bynes were leaving. She was running late. Had she not been running late, she could have walked into that situation, and she had a young child with her. So she also had psychological harm, knowing what could have happened, what did happen to her friend in her residence. We also have serious economic harm. The restitution request is for $1,298 for Mr. Gonzalez.